Yeah. Okay. Good morning. Can everybody hear me? Yes, I think we're live. Well, welcome to this panel, everybody, on IP protection of GIs. My name's Gordon Humphreys, and I'm chairperson of the first Board of Appeal at the EUIPO. I see we've got people from quite a few different countries, even outside the EU. So welcome to this session. And I think that this reflects really the importance of the subject internationally. Now, according to Commission sources, the price of a GI product is actually nearly 2.25 times that of a comparable non-GI product. But despite this, food and drink products that are GI indicated produce over 100 billion euros worth of business, of export business for the EU. So GIs are really valuable collective IP rights, and they actually, like trademarks, extend potentially for an unlimited period of time. And obviously the intersect with trademarks, because of this, sometimes causes fireworks. Now, we've got a great panel for you today. We've got 3 expert speakers, one drawn from the legal profession, another from the business environment, and our third one from the EUIPO. Now, the way we're going to do it is we're going to hear from our experts first, and then we're going to open up the floor for questions and answers. So I'd ask you to actually raise your hand, because that will be the priority in which we take people for questions. But if you're reticent to do that, by all means, use the chat, but be aware that priority will be given to those that raise their hand. Now, we'll start now with our first speaker, Paola Ruggiero. Now, her daytime job is as head of trademarks at Bird & Bird in Milan, but today she's representing ECTA, since she also chairs the ECTA's GI team. She'll be talking to us about the scope of protection relating to components of compound GI names. And she'll be looking in particular at the thorny issue of generic terms contained within a GI, and the problem of determining whether a particular term in a compound name GI can be considered generic. This is particularly relevant to the Torta del Casar case that I've actually been involved in myself with, and which she will bravely be discussing. So without further ado, I hand the floor over to Paola. Please. Unmute.
Yes, no, I was disappeared the unmute button, but now I have. So I should control the presentation, but I'm not able to see the presentation. Okay, here we are. Thank you, Gordon, for the kind introduction, and good morning to all. Subject of this presentation is the scope of protection granted, or maybe not, to components of compounds geographical indication and name. In order to frame the matter, making reference to Regulation 1151/2012 on no. Can I come back? How can I come back with the slide? No, okay, here we are. Sorry. Making reference to Regulation 1151/2012 on quality schemes for agricultural products and foodstuff, I have grouped the main relevant article in this slide. Since diplomatia is made by expert, and having only 10 minutes for this presentation, this is just a quick summary. We have Article 6, which contains the definition of Article 3.6, which contains the definition of generic terms. Article 5.2, that are the requirements for geographical indication. Article 6, limit of generic use. 13, which is protection. 14, relation between trademarks and geographical indication, and then 41, which is the exception in case of prior use for generic term. Let's go now to see some case law. There are several case law related to compound geographical indication name, which had very different outcomes. I'm starting with Grana Bibagi. This case is, in my view, one of the milestone case, cheated in several decisions related to this specific matter. In a nutshell, the Italian company Bibagi filed an application for Grana Bibagi. The Consorzio filed opposition, and both the opposition division and the EUIPO Board of Appeal dismissed the case. In particular, the Board of Appeal stated that being the name Grana generic, the contested application could not be refused on the basis of the PDO Grana Padano. The court has annulled the contested decision, and in particular, the court stated that the frequency with which a term appears on the internet is not capable of itself of establishing the generic nature of a name, that the Board of Appeal was not in the position to come to the conclusion that registration of the Grana Bibagi did not constitute an infringement of the PDO, and that the board also erred in finding that the name Grana was generic, and that the existence of the PDO that did not preclude the registration of the mark for the purpose of Article 14. The court also stated that according to the regulation, the Board of Appeal was required to carry out a detailed analysis of all the factors which could establish the generic character of an agricultural products or foodstuff. And in particular, that the board should have considered the legal, economical, technical, historical, cultural and social evidence, which makes possible to carry out the analysis. And inter alia, the factor should have been the relevant national and the EU legislation. The board could have carried out survey of consumer in order to understand their perception of the name, opinion of the scientific group of experts for designation of origin and geographical indication that was set up by Commission, and also other factors such as inter alia, the definition of a name as generics in Codex Alimentarius. Then I will move to a very interesting pending case. This case is pending in front of the 5th Board of Appeal of EUIPO, and is Torta del Casar versus Queso y Torta della Serena. As in Grana Bibagi case, the Board of Appeal dismissed the opposition, stating that the term torta does not designate a geographic area as such, but that torta is designates simply the merged shape of the cheese. Torta del Casar lawyers, which have been fighting against all type of trademarks which include the term torta for cheese, appealed the decision, and the case and the court annulled the contested decision, stating on one hand that the Board of Appeal erred in pointing out that the term torta does not designate a geographical area as such, without having analyzed in details the term that if the term torta constitute a traditional name within the meaning of the regulation 1151. And on the other hand, by excluding that the trademark apply for would evoke the PDO Torta del Casara for the mere reason that the term torta did not indicate a geographical location. The Board of Appeal now, in order to assess the nature of the term torta, has for the first time in the history of the board appointed an expert, Professor Martin Gutierrez. According to the public available information, Mr. Gutierrez has already rendered his opinion in January this year. Anyway, due to COVID and to questions that have been sent to DG Agri, all the process took a long time. Indeed, we have to consider that in the EUIPO proceeding, there are 2 rounds of exchanges, and in a case like this one, this would mean a lot of documentation to be examined and commented. But always, according to the information I have, EUIPO is now in the final stage, and possibly the decision will be issued within the end of the year or maybe at the beginning of the next one. I guess that in any case, probably this will not be the last step in the Torta saga, even though it has to be recognized that even though the parties may disagree with the outcome at the end, they probably will no more in the position to say that EUIPO didn't take all the necessary procedural steps to find out. It will be difficult, for example, to sustain that EUIPO didn't reason the decision because they have examined tons of documentation and evidence. Last case I would like to bring to your attention is another pending case, and is Aceto Balsamico di Modena case. This case, in my view, is very peculiar. Here we have Balema that has selling products under the designation of Balsamico in German. The Consorzio served a warning notice to Balema that in its turn brought an action in the German court seeking a negative declaration to the effect that there had been no trademark infringement. That action was successful, but then Balema appealed, and in the appeal it sought a declaration that it is not obliged to refrain from using the designation Balsamico for vinegar products produced in Germany. The appeal was upheld, so the Consorzio appealed the case to the referring court, and the Federal Court of Justice referred a question to the General Court that answered saying that Aceto Balsamico di Modena is protected as a whole, and the protection is not extended to its compound aceto, balsamico, and aceto balsamico. This, in my view, does not mean that no protection at all shall be granted to balsamico and to its compound under the Article 13. And indeed, the General Court of Justice, by the decision of May 28 this year, referred the case back to the higher court, regional court for a new assessment, stating that the fact that the protection of a protected geographical indication, in this case aceto balsamico di Modena, does not extend the use of the individual non-geographical element of the same, such as aceto balsamico and aceto balsamico, in a product's name, does not exempt from examining whether, taking into account the additional linguistic and visual characteristic of the products, such as such a use represents an evocation pursuant to Article 13 of the regulation. Probably the lesson we can get, at least so far from the proceeding, and without entering the merit of the case, which is still pending, is is that also a term for which there can be an issue of protection within the protected compound name can nevertheless give rise, considering, of course, all the circumstances of the case, to a situation against which the compound PDO-PGI is protected, such as evocation, misleading practices, or violation of regulatory or unfair competition provision. So far, it's all. Let's wait for the relevant decision, and thank you. Gordon?
Yeah. Hello. Okay. Yeah, my apologies. I've been having some internet problems here. Yes, so Simone Calzi is our next speaker. Simone heads the legal department at Prosciutto di Parma, and he's been there for over 16 years and has obviously a wealth of expertise in defending a world-famous GI, and has particular expertise in labeling. He's going to be talking to us about the scope of protection given to GIs from the perspective of goods and services, as well as the role of evocation and reputation. So Simone, please, the floor is yours.
Thanks, Gordon, and thanks to the Commission and the EUIPO for this invitation. And I'm going to get my presentation. Just try to see if I can find it from my screen. Second. I'm sorry, I can't find it right now. I'm sorry, Gordon, I'm having issues to share my presentation. So
can one of the technicians please upload Mr. Calzi's PowerPoint, please? Okay. Okay, good. There you go. Okay. Unmute, please, Simone.
I see the presentation now, so sorry for the inconvenience. And I'm going to give a brief screening about the GI protection situation and the relative issues that are now on the table. And first of all, but okay, I can't manage my, okay, yes. Okay, sorry. Yes, I can say that the strongholds of the GI protection are the GI regulation, and that were able to be tapped for the 4 regulation, as you know, and someone already talked about the fact that we can consider to have just one regulation for all GIs. They established the rules also protection for agri-food, wine, spirits, and aromatic wine. And this regulation allowed the GIs to have a real impact on the market, because they were able to spread in Europe and to have also from big to small GIs benefit. They have benefit from GI protection in Europe and also not in Europe. And the borders of the GI land that was built up through the regulation was then defined and evolved with the help of the jurisprudence from mainly from the one of the Court of Justice and also through the one of EUIPO. In this sense, I would like to mention the recent decision taken by the Court of Justice that were very good regarding the GI protection. We can see the Court of Justice focuses the decision and the cases on the concept of evocation, and we can see that from the cases just mentioning the recent ones, from the cases of the Calvados Verlados, through the cases Scotch Whisky, Glen Buchenbach, and Queso Manchego, and it was taken into account the content of evocation, first from a phonetic, from a point of view of the phonetic case, then to concept of proximity, and then to adjust with the figurative elements in the case of Queso Manchego that was sufficient to verify the presence of evocation and to enlarge, enforce the GI protection, in my view. Then I would like to mention some recent decision taken by EUIPO that was a very good spring for GIs due to the EUIPO decision. The first one I would like to mention was the refusal of a trademark application containing the term algao. And it's just not a product denomination, but it was like a slogan meaning more of algao cannot be found in any other cheese. And the court, rightly, in my view, stated that this term was sufficient to trigger in the mind of the consumer the 4 PDOs cheeses, German PDO cheeses, containing algauer in their denomination, and accordingly the trademark application was refused. So it's important to underline that in this case it was not an identical term, and the use of algao was in a sentence and not in a product denomination. So it was important because we are seeing that the EUIPO applying correctly Article 7 of 1J of trademark regulation, and we're considering EU regulation and also the specifications of GIs that obviously are regulations themselves. Another good decision for GI protection taken by EUIPO was the recent one taken in May 2020. It was the trademark application for the Port Ruiz, and there was a whiskey that was refused as considered evocating the PDO Porto and port due to the consideration of the court was relating to the fact that even if there are different products, I mean wine for Porto and whiskey for Port Ruiz, the goods are similar and addressed to the same consumers, and also the application is likely to affect the consumer preference by let the consumer believe that the Port Ruiz followed the same specification of the wine Porto that has an exceptional reputation. So the trademark application was rejected. It's interesting to underline that the court stated that the case is different from the Port Charlotte one, because in this case, roof is has not a specific meaning, is meaningless for the consumer, so there is no reason why the relevant public could associate the port roof to something different. And so the first relation would be the one with Porto. So this good decision were all taken regarding the protection with the related to products for the GIs. But the questions that could overcome now is that the GI, if the GI protection could also be enlarged to goods and services, and not just referring to products. And in this sense, we have to underline firstly that already in the GI, most important GIS regulation, I mean the one regarding wine and the one regarding agri-foods, it's mentioned in the regulation regarding wine at Article 103 2, and in the EU regulation 1151, it's mentioned at Article 13 the fact that the protection should regard also products or services. But I have to say that this concept is surely evidenced more clearly in the recitals of both regulations, where it's stated that the protection for GIs should be extended to products and services. So I wasn't surprised when EUIPO took this also other relevant decision last April. That was a trademark application. It was an opposition of Champagne for the trademark application Champagnola that was interested to underline that was taking different classes rather than the one of Champagne, meaning namely class 30 for bakery goods and 40 for bakery services. And it's important to underline that the Commission took the decision. Sorry, I have some mistakes in the presentation. Just a second. Was here? Yes, right. The EUIPO took its decision on basing it on 3 criteria. First of all, it referred to the fact that to consider if there was evocation in the term Champagnola referring to champagne, it's easily to verify that the evocation is clear, and also the EUIPO stated the application applies whether or not the product or service are comparable, which is an important principle. And then the other criteria was the one related to the reputation. So, and obviously it's easy to recognize the champagne as a great reputation, not just in Europe but and all over the world. And maybe the most important, interesting criteria was the one related to the reputation exploited. And in this case, the EUIPO stated that it wasn't required the prior use of the trademark. It was enough to prove the evidence of a future risk of the use of this term for champagne, and the future risk was verified by the fact that due to the EUIPO decision, the champagne is a product that can be consumed also at breakfast, or can be related to bakery services. And so for this consideration, and due to the criteria I mentioned, the application was refused, and it was a very important decision. We will see how the Court of Justice will decide in the case Champanillo that was already mentioned in the yesterday panel. We know that in this case there are bars in Barcelona naming Champanillo, and there is obviously there are the cases at the Court of Justice intention of verify if the extension of protection of the GI could regard also goods and services, and in this case, in my view, I hope that the decision of the Court of Justice will be in line with the EUIPO one I mentioned. And also another important case at the Court of Justice is the one regarding more BA, and already mentioned yesterday. I mean, regarding the shape, if also the shape or a specific characteristic of GIs could be covered by protection, could be a case of infringement if another generic product reproduced this specific characteristic, and we understand from the judge of the Court of Justice yesterday the decision is going to be taken within a month. So, and that I hope the decision will be in line with the conclusion of the Advocate General Petruzzella that were very good in my view. And as an end on the concept of the GI's protection borders, I can say that I deem that they are still undefined, because there are many challenges on the table again. One, for example, regards the internet and the domain names regulation. The other regards, for example, the presence of GIs in the foodstuff product, and the lack of uniformity of legislation at the EU level on this topic. And also we know that there are issues for GIs in the third countries, and we hope that these issues in the countries where GI systems are not recognized could be solved through the EU bilateral agreements. For example, one on the table important is Mercosur, and we have a good example for us. That is the one of CETA, the Canadian EU agreement, where the Prosciutto di Parma could finally obtain the chance to export in Canada with its denomination after many years of legal battles. So I end my presentation, and I hope Gordon to remain in the timing, and sorry for the trouble at the beginning.
No problem. Thank you very much, Simone. Listening to you, it does sound, when we talk about evidence of future risk, it does start to sound a bit like trademark tests for reputation. That's maybe something that a theme we can come back to, whether we've actually strayed into tests for trademarks in the realms of GIs. Now, let's move on to our final speaker, Mr. Stefan Martin, who's a colleague of mine at the EUIPO Boards of Appeal. Now, Stefan is passionate about GIs. He's in fact a prize-winning author on the subject, and in his spare time, like Paola, is very much a knowledgeable foodie. Now, he's going to take us on an overview of the landscape of the problems faced by decision takers in upholding GIs in the intersect with trademarks. So, Stefan, over to you. Thank you.
Thank you very much, Gordon, for this nice introduction. So I will actually raise more questions that I will provide answers in relation to issues that are still open in relation to the process of the examination of trademark that may be in conflict with geographical indications. So my first remark would be that we have too many sources in terms of, and I will illustrate here that it's one decision that was actually taken by Borden's Court. It's a Lucky Lasso Kentucky Straight Borden. And in one paragraph, they started in paragraph 13 to say, for ease of understanding, the following table is a list of the provision relevant to the case. And you have here 5 different regulations that have played a role. I think that it would be advisable if we could simplify the legal framework for geographical indication. Second aspect, there are certain omissions in the regulations. So, for example, if one takes Article 7, which pertains to the protection of geographical indication in conflict, when trademarks are in conflict, you can see here that in Article 7 we have trademarks which are excluded from registration pursuant to union legislation or national law or international agreements. However, in the same regulation at Article 8.6, when one is speaking about opposition proceedings, here we have just union legislation or national law. So the international agreements have vanished suddenly from the definition of Article 8.6. This omission has been, I would say, cured by a decision of the Fifth Board in this Bourbon, where the Fifth Board said that the reference to union legislation and national law naturally includes international agreement and they form part of the legal order of the union. I think the position is right. However, we could at least try to uniformize both concepts within the same regulation. Next topic that I will be addressing is we have, as you can see here, we have apple and oranges. And so that leads to different concepts. I'm sorry, I have a problem with. And here I'm talking about different concepts in international agreements. So for example, in this agreement between Chile and the European Union, we have just a reference to a certain acts that are prohibited by the agreement, but with no reference to misuse, imitation, or evocation. As we know, evocation is one of the key points and the key tool to protect geographical indication, as we have seen from our two previous speakers. So evocation is not in that agreement. I think that we should, if possible, obviously, try to have the same similar concept as we have in a regulation in our international agreements. Here, if we take, for example, the most recent agreement of 2019 with China, here we can see we have, again, another wording of the scope of protection of GIs in relation to trademark. If we go then to the agreement with South Africa, we have again another concept. So three different concepts, three countries, Chile, South Africa, and China, three different concepts, three different scope of protection. This is kind of disturbing, I would say. Next topic is about how to find the different international agreements. And here it is kind of complicated because if we would have a look to where can I find the international agreement, for example, the most recent one that we have signed with Armenia, where can I find the most recent one that we have signed with Vietnam? It's not so easy. And I think that we should take advantage of Article 104 of the 2013 regulation and try to have a cooperation in between all parties that are involved. We should, I believe, go ahead with a GI view, but we should also create a database of international agreements with the date of the agreement when they came in force, etc., etc. That would be very helpful, not only for practitioners, but also for people that are involved in this area. Next topic that I would like to briefly address, I think that certain things have become, certain provisions of the law have become useless. For example, I don't think that in the 4 agreements that we still need a specific article for the relationship with trademarks. Why not? Because we have now specific provision in the regulation and in the directive dealing with the relationship between trademarks and protected geographical indication, and therefore I think that we could eventually take out from the 4 regulation the specific provision dealing with trademarks. Next subject, we have here 3 concepts, evocation, misuse, imitation. The court has defined what is considered to be an evocation. However, we have as yet no indication what is meant by misuse, imitation. The Advocate General Jacobs 20 years ago has tried to define it, but still there is an issue. And we have here, for example, 3 situations. You have Roquefort Société, then you have the Saint-Agur, which is a Roquefort, kind of a blue cheese, but made with cow milk. And here that's a new thing from Roquefort, bleu de brebis. Here, are we here confusing the consumer? Is it an imitation? Because you can see that there is the imitation of the packaging. Is there just evocation? We have no clue. Maybe in this regard, the legislator could define what is meant by these three different concepts. We have also issues regularly with legal standing. Article 8.6 of the trademark regulation provide that any authorized person under the relevant law may exercise the right arising from a designation of origin. So we have left that to various legislation in the member states. However, if we go to Article 22 of the TRIPS agreement, we have interested parties. If we then go to the Paris Convention, it is mentioned under Article 10 ter, we are talking about federation, association representing interested industrialists, producers, or merchants. If we then go further even, then we go to the panel report that has been issued under the TRIPS agreement. Here we have another concept. And in the Geneva, we have again interested people. And if we have a look to Article 45 of the food regulation, it takes here the role of group, and a group is entitled to ensure adequate legal protection. So here we have kind of a double approach. In the trademark regulation is national law. However, here in community regulation, the law seems to give an important role to groups that would be entitled to seek legal protection. And I believe that the interpretation, the reasonable interpretation of Article 45 is that adequate legal protection means also opposing to the registration of a trademark. And therefore we could have here a conflict between Article 8.6 and Article 45. Maybe that should also be addressed. So very quickly, a next difficult subject for in the examination process is the protection with regard to GIs with reputation. So what are we talking about? What is this type of reputation? Here we have two bottles of wine. One is the Romanée Conti. It's certainly the most famous wine on the earth. Why that? Because it's a very small piece of land, 1.5 hectares. I think they're producing 6,000 bottles a year. So you can imagine that that is a specific thing. Here you have on your right-hand side a very good wine, which is a Pic Saint-Loup. It's from the region between Nîmes and Perpignan, in that region. This one has also reputation, but are we talking about the same reputation, Romanée Conti and Pic Saint-Loup? Obviously not, and I will come in a second. So the protection that is provided by the full regulation for reputation is insofar as use, exploit the reputation of a geographical indication. Good. So we have here two important words, exploit the reputation. However, that reputation shall not be confused with the reputation under Article 8.5. And to come back to what has been addressed by Gordon in one of his remarks, where he said, look, we have here maybe a tendency, a trend, to assimilate the protection of trademark under Article 8.5 with the protection of reputation for geographical indication. I don't think that we are talking about the same thing. At least the law does not support such interpretation. Because in English, we're using both words indifferently, reputation and reputation. However, if you take a look to the French, Spanish, Romanian, Dutch, and so on version, you will see that we are not talking about the same thing. In French, for example, under trademark law, we're talking about renommée. Under GI's law, we're talking reputation. Same thing in Spanish, renombre, reputación. Romanian, etc. I will not go through all the language version, but that is a strong indication under the principle that if the legislator uses different words, this means that these are different concepts. So we should not amalgamate the principles that have been defined under Article 8.5 of the Trademark Regulation and try to import them to the others. The reason for that is also not only from the perspective, from a legal perspective, but it's also that reputation in the sense for GIs is something else. And that has been defined by the Court of Justice on at least 3 occasions, because what the court said, it said that the reputation of a PDO depends on its image in the mind of a consumer, and that image in turn depends essentially on particular characteristic and more generally on the quality of the product. So here we see what we are talking about. Reputation is the quality of the product as it has been memorized by the relevant consumer. And that obviously has a direct impact of the scope of protection. Because when we come to exploiting the reputation, it's not the same thing as taking unfair advantage as in trademark law. So we should avoid this amalgamation of 2 concepts. And this is exactly what the Board of Appeal in 2 cases that has been mentioned by our friend, Porto Gin and Porto Rouge, has tried to convey the message that we are not talking about the same reputation. This being said, what is exploitation of the reputation? And here it is actually more difficult for the examiners, including for any person who are going to decide, whether it being the Board of Appeal and later on the General Court or the Court of Justice. What is exploitation of the reputation when compared to, for example, taking undue advantage of the reputation? Exploitation of the reputation is something which is less demanding, and that is what the board has said, as undue advantage. Exploitation of the reputation will be that as soon as someone tries to register a trademark or is using a trademark that for different product, but that this product have a certain proximity with the products that are covered by the geographical indication, we have, I believe personally, an immediate transfer of the image of the GI, and therefore we have immediately an exploitation of the reputation. So this is a difficult subject. The courts have not spoken the last word of that issue. I have tried in 10 minutes to provide you with at least from the perspective of the examination, but also the opposition of issues that are still open or that could be resolved in the course of a modification amendments to the 4 basic regulation. I thank you very much for listening to me. And now I go back to our moderator, Gordon. Thank you very much.
Thank you very much, Stefan, for that interesting presentation. I would just say that, of course, undoubtedly you're right about the need to distinguish between reputation in a trademark sense and reputation in the context of GIs. It's really unfortunate that we're using words like proximity, transfer of image, and undue advantage, though, to do this. That doesn't really sound like we're getting the right message across. So I wonder about that. Anyway, let's now open up the floor to everybody. Let me see if we've got any questions at this stage. I'm just scrolling down. Well, if not, it doesn't look like any hands are raised. So I'm just going to open up, in the chat. Yeah, there's a question addressed to Paola Ruggiero regarding what the Court of Justice declared in the Aceto Balsamico di Modena ruling, that it doesn't extend to the use of individual non-geographical terms of that name. So what are your views on how the German court will have to apply this judgment, and what can you say about that judgment of the Court of Justice, Paola?
Wow, it is a very big, very big question. So, indeed, the German court, at least the federal one, already said something, and that is that the court should have examined the case under other profile, such as evocation or misleading practice and so on. What the court now is going to do, or what we are expecting from the German court, it's really hard to say. I'm in a very bad position in this case because I'm assisting aceto balsamico. So if I have to tell something is in favor of aceto balsamico, of course. And but just this is apart from this case. What I think is that really linguistic indication and other factors which are has to be considered in examining, because if we are in German and the products is presented only with Italian word, I'm asking why. You are mute.
Yes. Thank you very much, Paola. Well, at the moment, I don't see any other questions from the audience. I've just been asked to make one little correction to what was said about the GI view. It appears from the information I've just received that, in fact, it is possible to consult and have details on international agreements. So just so that everybody's aware of that. Now I think I have a question. We have one that's just been raised in the chat. Does the use of the generic term primitivo in a device trademark application and then in the market constitute an infringement of the GI, the famous GI Primitivo di Manduria? The trademark application bears other distinctive features. This sounds like our Italian panelists would be best placed to answer this.
Oh my gosh. So the answer to this question from my point of view is that I'm not the right person to judge to answer to this question, but the question I have a question. Why you need to file a trademark including the word primitivo in your label? If you have a right to use it, but why to register it? Where is the benefit of registering a trademark which include a geographical indication? Of course, these are words by a person who is passionate about GIs. But what I think is that geographical indication should not be part of trademark of the users. They are something that shall be defended. By the way, the answer could be yes, it could be a violation.
Okay, thank you for that. Then a question to all of the speakers, and it's a little bit of a controversial question. It's, in your opinion, what's the level of knowledge of judges at national level? Thank goodness not the boards of appeal members. In the EU member states as regards conflict regarding GIs, and how could this knowledge be improved? So judging by the question, the questioner's not too happy with that knowledge. So over to the panel.
If I can, Gordon?
Please.
Simone. Yes. it's a very good question and tricky question. I know the person who posed this question, and I know she knows that it's an issue. This is the fact that sometimes we have judges over EU member states that do not apply properly the principles set by European Court of Justice and also the EUIPO decision. So, but how could this knowledge be improved? Maybe it's something that regards the communication of these sentences, and they're spreading all over EU member states. Maybe sometimes also by government. But I have to also to say that the judges, if a person is a judge, they should know and should understand the principle of Court of Justice. So I agree with this remark by my colleague.
Thank you. We've only got a couple of minutes left, so I'd just like to bring Stefan into the debate. Stefan, you mentioned about the various sources. What about the fact that there's so many, that we've got appellations of origin, denominations of origin, PGIs, PDOs? Do you think that's confusing for the general public? And how do you think it's perceived internationally? Unmute, please. You're muted.
Yes, I totally agree. As you know, I have been practicing law for 20 years in Canada, and all these different words are kind of confusing. There are too many. However, the fact is that these different words reflect also different situations. One where the product is made and it's more the savoir-faire that is protected, one where all the ingredients have been blah, 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 and so on and so forth. And I think that it's kind of difficult. What is also difficult is that, for example, when in the states, member of the union, they were using different words in the past, and then, for example, as in French. And now, through this unification at European level, they are using another word, and that is also confusing, and for the general public on top of it. So I agree with you that here I have to say that it's difficult because there are many concepts that are involved, many different concepts.
Okay, thank you. We have another question. It seems like we've got some people with test cases on their way, saying that for trademarks in class 33, Mediterranean or Mediterranean, should that be considered as an infringement of the PGI? Would the panelists like to give some free legal advice here? Please unmute if you can.
Okay, I guess that there is already a case open on this, so I guess that who asked the question can just give a look to the ongoing case. It depends. I guess that it's not easy to answer yes or no, because a lot of information are missing.
I'm going to have to cut you off because we're about to be, but thank you to the wonderful panel, and thank you for all the explanations and for the interesting questions we've had from the audience. And it's been a great pleasure to host this panel. Thank you.
Thank you.
Bye-bye. Bye-bye.
Bye-bye.